Good afternoon, Mr. Augusta.
Good afternoon, Tony. How are you, sir?
I'm doing fine. Just got a couple of clarification questions for you. And I'm talking about the panel the way you proposed it. You stated that police departments are a paramilitary organization. In the military, who are military personnel judged by if they get in trouble?
Well, customarily, you have a court martial.
And they're made up of
various members of the armed services.
correct. And if a lawyer gets in trouble, does he go before a board or something to determine whether or not he should be suspended or lose his license?
That is true, but my understanding is that is not a board comprised exclusively of members of the bar. So there are some various constituents, members of the community, the judiciary, and otherwise. I may be incorrect about that, but the last I checked, I think law enforcement officers in Rhode Island and other states that have Bill of Rights are one of the few professions where they're judged exclusively by their own.
Well, we got examples of several other states' Bill of Rights that have panels made up of police officers also. And I think there's a reason for that. Just like in the military, there's a reason. Police officers know the police profession, just like military people know the military. Lawyers know, and doctors know the medical profession. And that's why these other professions are judged by their own peers, because they all understand the workings of it. So if a police department is truly a paramilitary organization, which I've always been told for many years, and they are judged by military personnel for their, if they get in trouble. I believe that's the reason why police officers in that panel were set up that way. And I do know you remember this because you were around, and I had mentioned this last hearing as far as the panels, the way they're picked, and going to the courts to have additional people appointed. As you know, this is very much this way that arbitration panels are picked for arbitration. And I know you remember many years ago when Judge Weisberger was the chief judge of the Supreme Court. Prior to that, the courts appointed neutral arbitrators if you could not. When he became the chief judge, he changed that practice to get it out of the hands of the court. So we don't even know if the courts are willing to take on this additional responsibility.
If I could respond to that, I think you're really addressing something that's apples and oranges in this sense, Tony. The change in the interest arbitration statutes related to the construction and the composition of labor contracts where there was impasse between the parties. LEOBoR deals with holding police officers accountable for offenses that fall below the standard as enunciated by their rules and their regulations. Now, I will say this. We all know that juries, and I see the Attorney General's here, and he's a very experienced trial lawyer, and he will tell you never underestimate, as I think most lawyers would say, the common intelligence of those that sit on a jury. And a jury is perfectly capable of understanding what the rules and regulations and standards of conduct are by police officers in a police department, and they certainly are capable of weighing and parsing through evidence to determine if there's been some violation of those rules. I might also add that LEOBoR has an added feature that the commissioners should not forget, and that is the right to appoint legal counsel. So every hearing committee can be assisted by a lawyer that could advise them about the way to view the evidence in terms of the burden of proof, questions that they might ask, addressing any kind of legal issues. So citizens participating along with police officers would provide a very good mix and give, in my mind, some transparency and some balance to this process. Because currently it is, frankly, a roll of the dice, the proverbial dice, in terms of the composition of the hearing committee. I have had some very thoughtful police officers that serve as neutrals. They've listened to the evidence carefully. They've shown complete objectivity and impartiality. But then again, I have seen some that think because they are police officers, they can view it through a different prism. And let's also not forget that civil rights violations alleged against police officers are typically tried before a jury. So there absolutely, in my view, is no justification to disenfranchise citizens from participating. As far as the role of the Superior Court is concerned, or the Rhode Island Commission for Human Rights, or the Rhode Island League of Cities and Towns, the role would be essentially administrative in terms of developing a list and then making selections. I think the point I want to emphasize here is we need to have a broad perspective of individuals looking at police misconduct. Representative Williams' suggested name change, I think, is very telling. LEOBoR would now be called, and I want to make sure I get this right, I think the name change is the Law Enforcement Officers Accountability Act. As public employees, police officers are accountable to the citizenry at large for their conduct. And so injecting citizen participation as triers of fact and to make value judgments about the conduct of police officers, I think is perfectly appropriate. And I think that's what the public is calling for today. It's very apparent, and I do not think that it is necessary, simply because agencies are paramilitary, to limit the composition of the hearing committee to police officers only.